Judgment in the matter of the Republic of Mozambique against Privinvest Shipbuilding.
This is the first of two appeals which were promulgated in the summer during the court recess, one in the Supreme Court and the other in the Judicial Committee of the Privy Council. Both are concerned with the relationship between the courts of law and arbitration. They are concerned with the circumstances in which the court should stay its proceedings to allow a dispute to be determined by arbitration in accordance with the agreement of the parties. This is a question that arises in many jurisdictions. In English law, which is the subject matter of this appeal, it arises under Section 9 of the Arbitration Act 1996. Section 9 provides that a party to an arbitration agreement against whom legal proceedings are brought in respect of a matter which, under the agreement, is to be referred to arbitration, may apply to the court to stay the legal proceedings so far as they concern that matter. The legal issue in this appeal is the meaning of the word matter in that statutory context. The dispute arises out of allegations made by the Republic of bribery by three companies in the Privinvest group to senior officials of the Republic and employees of companies in the Credit Suisse group. Different Privinvest companies contracted with three special purpose corporate vehicles, or SPVs, for the development of Mozambique's exclusive economic zone. Those SPVs borrowed large sums of money from Credit Suisse to fund the purchase of the goods and services, and the Republic guaranteed those borrowings, exposing itself to potential liabilities under the guarantees of approximately $2 billion United States dollars. In each of the three supply contracts between a Privinvest company and an SPV, there was a widely worded arbitration clause which referred to arbitration all disputes arising in connection with a particular supply contract. Although the Republic was not a signatory to those supply contracts, the Privinvest companies assert that, under the governing law, which was Swiss law, it is bound by the arbitration clauses. The appeal before this court has proceeded on the basis that that assertion is correct, but a trial now underway in the High Court will test that assertion. The background is that the Privinvest companies assert that they provided valuable goods and services which the Republic has squandered. The Republic contends that the contracts were not performed properly and were not of significant benefit to it. The Republic sues the Privinvest companies in England for bribery and unlawful means conspiracy. The preliminary issue which the appeal addresses is whether the Republic's claims against the Privinvest companies are matters which fell within the scope of the arbitration agreements. At first instance, Mr. Justice Waxman held that the claims were not within the scope of those agreements. The Court of Appeal disagreed, and the Republic appealed to this court. This court unanimously allowed the appeal. As Section 9 of the 1996 Act gives effect to the New York Convention, the court addressed the jurisprudence of other countries with similarly worded statutory provisions and adopted broad and generally accepted principles in interpreting the 1996 Act. In that review, the court identified a general international consensus on the meaning of matters which must be referred to arbitration. First, the court held that it adopts a two-stage test. The first stage is to identify the matter or matters which the parties have raised or may foreseeably raise in the court proceedings. The second stage is to determine, in relation to each such matter, whether it falls within the scope of the arbitration agreement. This involves ascertaining the substance of the disputes without being overly respectful of parties' pleadings and having regard to defences that are reasonably foreseeable. Secondly, A matter need not encompass the whole of a dispute between the parties. Section 9 expressly provides for a stay to be granted in respect of part of the proceedings. Thirdly, a matter is a substantial issue that is legally relevant to a claim or a defence which is susceptible to be determined by an arbitrator as a discrete dispute, rather than an issue that is merely peripheral or tangential. If the matter is not an essential element of the claim or of a relevant defence, it is not a matter in respect of which the legal proceedings are brought. Fourthly, the test entails a matter of judgment and the application of common sense. It's not to be applied mechanistically. Although there is as yet no consensus among the signatories of the New York Convention, the Court in its judgment made a fifth point, holding that when addressing the second stage of the analysis, the Court must have regard to the context in which the matter arises in the legal proceedings and recognise a party's autonomy to choose which of several possible claims it wishes to advance. The Court held that the substance of the controversy in this case is whether the transactions were obtained through bribery and whether the Privinvest companies had knowledge at the relevant times of the alleged illegality of the guarantees entered into by the Republic's officials. The assertion by the Privinvest companies that the supply contracts were valid and on commercial terms would not be a relevant defence on the question of liability. It would only be a partial defence in relation to the quantification of the Republic's claims. The Court did not find it necessary to decide whether the quantification of the Republic's claims is a matter in the legal proceedings because it decided the appeal by reference to the scope of the arbitration agreements. In relation to that question, the Court noted that the context is one of multiple arbitration clauses focused on individual contracts. Rational business people were likely to intend that any disputes arising out of their contractual relationships be decided by the same tribunal. In this case, the arbitration agreements do not cover the question of the liability of the Privinvest companies. Rational business people would not seek to send the partial defence to the quantification of the Republic's alleged losses, which is a subordinate factual issue, to arbitration. The Court therefore allowed the Republic's appeal.